So welcome everybody to this policy discussion series organized by IG. So we are having a regular panel discussions now on various policies in the context of the Indian economy. Today's discussion is about the labor reforms and employment. And as we all know, employment has been a concern for a long time now for the Indian economy. And now, during the COVID-19 situation, it again came to the fore. And then of course, the labor reform came. Really now this is we all felt that this is the right time to revisit the employment scenario. And we have a very distinguished panel today to discuss all these different aspects. So we have Professor Ravi Srivastava from Institute of Human Development. We have Professor Shyam Sundar from XLRI Jamshedpur, Professor Alakh Sharma from ISG, Professor Amit Basole from Azim Premji University, who is going to join us a little later, and Professor Arup Mitra from IG. And the event is going to be moderated by Professor Ajit Mishra from IG. So over to you, Ajit.
Thank you, Mausumi. As you can see, we are very lucky to have this panel. Just before we went live, I was commenting that we have the virtual Indian Society of Labor and the editorial board here. So, if you're asking questions, be nice and keep that in your mind. Because it's not that Amit will be joining us, but he's teaching till 3:30, so we're expecting him around 4. Now my job is very limited here. It says moderator, but I can't see. This is the discussion getting into extremes. Okay, so in that case, I'll step in. I can just tell a little bit about the context and how we came to be doing what we are doing today. As Mausumi said, we have been doing a series of discussions. So in fact, we have had 2 on agri reforms. And in fact, it was after the first panel discussion we had, and there was a lot of interest and a lot of discussion and so on and so forth, so much that we decided to have a second one. And that's when I came across, one morning I was reading Ravi's piece in Indian Express. And it really struck me then, and struck very, very hard that there's so much talk on the agri reforms, but somehow when the labor codes or the bills were passed on 23rd September, in fact now I know, but that time I didn't know the exact date and stuff like this, there was hardly any noise. Of course there was some this panel, members of this panel have talked about it or have written, but we didn't have that kind of attention, that kind of discussion, these things. And so then, I had a quick exchange with Ravi, and then we approached Professor Arup Mitra, who, as I was in the middle of the teaching actually, the IES teaching, kind of reached out to various members of this panel, and here we are. So I'll leave it to the panelists now instead of talking in abstract. So the sequence will be that I would invite Professor Arup Mitra, as part of the host team, to kind of kick off the panel discussion. Then we will request Professor Alakh Sharma, and then Professor Ravi Srivastava, Professor Shyam Sundar, and Amit, since he's coming late. It is best to. So he'll be the last one, okay? And then, so that's going to be, so each one is going to probably speak for 10, 12 minutes. That's roughly our plan. So for the second hour, we can devote entirely to Q&A. Because there were more than 100 registrations, we had to go for this webinar mode. So unfortunately, we cannot do it in a meeting mode. Our, Zoom doesn't allow us to do that. So please, type in your question in the Q&A box, then, and we're going to raise it, myself, Mausumi, and Angela, we can pick up those questions and put it to the panel. So it's all over to you, Arup.
Thank you very much, Professor Mishra. It's a pleasure on my part to share my thoughts on these labor reforms. And also I'll try to present a little bit of exercises that I have conducted very quickly. Let me begin by giving you a very brief background about these labor code reforms. Recent labor reforms have a connection to the constitution of the National Commission on Labor, which was done during Atal Bihari Vajpayee's governments. That was the second constitution of the committee. And there are about 44 central laws and more than 100 state laws. Of course, Professor Shyam will be able to tell us the details about these laws. And what the standing committee did, it tried to consolidate most of these laws, particularly the central laws. The 44 central laws actually have been grouped into 4 codes. In fact, the committee suggested about 7,400 changes, out of which 74 have been amended. And these 44 central laws actually have been categorized into 4 important codes. So the first one is your wage code, which subsumes 4 major laws: the Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 65, and the Equal Remuneration Act of 1976. What it tries to do, it tries to provide a basis to formulate the minimum wages, etc. There are about 4 members in a household, in a laborer's household, and out of those 4, actually there are only 3 adult consumption units. The presumption is that women would be consuming less than the male members, and the children will be consuming 40% less than the adults, etc. And there are a number of criticisms. We will come to that when we discuss these codes in detail. Right now, I'm just trying to give you a brief outline about those codes. In fact, there is one strong criticism which suggests that 12 hours of work per day should be considered by each worker. But what about the domestic chores, particularly when it comes to women workers? Now, the whole attempt is to keep the wages growth sluggish so that the business feels tempted to operate and to generate adequate labor demand. The Industrial Relations Code basically puts restrictions on strikes. The units which are employing more than 300 workers will have the permission to retrench, and they will have to take the permission from the government. At present, what happens, the units which are employing more than 100 workers will have to take the permission from the government as far as retrenchment is concerned. So after these codes are implemented, we will be able to see that 100 to 300, the units which are employing 100 to 300 workers will be completely exempted. In other words, you are providing more sort of liberty to the employers. Now, the Social Security code basically tries to mention that reskilling fund to be used for reskilling of workers retrenched. Now, if you retrench me today, then you will have to contribute towards that fund. Now, if you have employed me for 15 days and you have paid me the wages for 15 days, then you will have to make a contribution. And the National Social Security Board will recommend to the central government to formulate various schemes to sort of retrain these unorganized workers. But who are the other stakeholders? That is not really known to us. So it is quite vague at this moment. Of course, it tries to address the concerns of the unorganized sector workers, the gig workers, platform workers, and it says that the aggregators will have to contribute about 1 to 2% of the annual turnover. And then there are many other clauses, but the whole issue is that the central government will receive a recommendation and then it will formulate a number of schemes. But how these schemes will be formulated is yet to be seen. Now, finally, the Occupational Safety, Health and Working Conditions Code. So here, I think in the backdrop of what we have seen during the lockdown, that the migrants going back to their villages, keeping that in view, this code has been formed. So the migrant workers who have moved from one state to another and are earning less than 18,000 rupees a month will be entitled to this sort of provision. So they will receive a journey allowance, and this has to be paid by the employer, etc. Of course, earlier this clause was there in an indirect manner, that the employer was supposed to provide shelter to the worker near the work site. But now that is gone. Instead, they say that a lump sum amount has to be paid by the employer to the migrant workers. And at present also we had this provision for the contractual workers. But now instead of contractual workers, the term is used as migrant workers. So all migrant workers will be entitled to this particular provision. So this will bring down the number of registrations required under existing labor laws. Right now we have 8, and that will be reduced to 1. Licenses and the number of returns filed under the labor laws also will be down from 8 to 1. So these are certain advantages which the Ministry of Labor feels that raise our probability of doing business in the global market in a significant manner. A formal grievance redressal mechanism has also been constituted, and so that the workers and the trade unions who have certain grievances can actually file their complaints there. So in other words, it's the end of what is referred to as Inspector Raj. However, we have earlier argued that in many ways it was possible to restrict the visit of the inspector, and it was possible to sort of introduce a number of backdoor entries, and hence it was possible for the employers to bypass these laws and sort of deprive the labor its due share. Now, these trade unions, they are arguing that the bargaining power of the laborers has been reduced substantially. In the name of flexibility, labor will lose its say. Absolutely. Now, in the backdrop of this, let me give you some quick results that I have tried to carry out. I have tried to estimate the wage sensitivity of employment. See, since much of the emphasis is on wage code. Wage code was actually was passed last year, and these 3 codes were recommended in September, and now it is in the public domain. Once the feedback will be received, then the approval for the President's assent will be required, and once that is done, they will be converted into laws. In the backdrop of that, so I am trying to work out what is the sensitivity of employment with respect insignificant. I mean, important to note is that it is most of these elasticity coefficients are statistically insignificant. So why are we then worried about so much about to pursue labor reforms? In the past, when the labor regulations were extremely tight, even then the employers could actually bypass those laws and could introduce several backdoor entries and could reduce the share of the labor. How they could do this? They converted the ratio from the regular to contractual and regular. In other words, during the 70s and early 80s, you would find that 70% or more of the employment could be attributed to the regular employment, and about 20-25% were contractual employees. As after deregulations, mid-80s and during the early 90s, you could see that the ratio completely changed in the reverse direction. Now the share of contractual employment in most of these industries is extremely high, and the share of regular wage employment has declined considerably. In fact, during the 80s and 90s, massive employment decline took place. How was that possible? If the labor laws were so strict, how was that possible? So that is what I am trying to argue. In fact, in that book, Corruption and Development in the Indian Economy, we had a chapter where we had shown that how the employers actually develop a nexus with the state governments, and then they try to bypass most of these laws, and they try to restrict the visits of the inspectors, and that is how it has been going on. So employers already had the flexibility. If you look at the labor share, it has been declining steadily in the organized manufacturing sector. During the 70s, early 80s, it was about 35%, 40%. And slowly it has come down to less than 20% in some of the industry groups. Yes, there is a positive side to this. The domestic enterprises knew the secrets, how to bypass the laws. But the foreign investors, of course, were not aware of these laws and were not aware of these secrets. And therefore, for them, the reforms was a must. So technology, we are trying to argue here is that limited role as far as labor demand is concerned. Rather, we should be concerned about the role of technology. The technology that we are innovating, the technology that we are importing is highly labor saving. So from this point of view, per enterprise, the employment is declining. Even if you, hypothetically speaking, even if you reduce the wages substantially, it is not really going to generate adequate labor demand. However, I would have a note of optimism by saying that with innovation of new technology, if the cost comes down, there will be many more new firms, and hence the scale effect will dominate the negative impact on employment per enterprise. So there would be more new firms, and hence at the macro level, even if the per enterprise employment declines, the overall employment will be rising. So hire and fire rule will have to be accompanied by support for job search cost. So that is what we have tried to argue. And also in the third code, you get to see that the government is trying to talk about this reskilling of the workers. Particularly if you retrench me, then you will have to pay for my reskilling activity. Now, political patronization of the unions had already declined since the early 90s. So hardly they could initiate strikes and lockouts. Productivity was not hampered much. Holding strict labor laws responsible for sluggish growth in employment is an exaggerated proposition, I would say. So rather, we need to deal with other issues, and without labor reforms, as I mentioned, the employers were able to get data of growth. Why will it not be inclusive? So my answer to him was that to have the role of intermediaries. The linkages between the formal sector and the informal sector is not sector workers to within the unorganized sector is already very low. So in such a fashion, if the wages would increase further, then obviously the profitability of the unorganized sector enterprises will decline significantly. And to what extent they will be able to retain in their position in the market is a very important question. I think I will stop here and then I'll come back later when you will pose certain questions.
Thank you, Arup. That was very nice. Okay. Now that I'm unmuted, let me welcome Amit Basole. He has also joined. Now,
okay, thank you.
Over to you. Do you want to share screens, or you just want to?
Who are inviting?
I'm inviting you now.
Okay. No, I am not doing PPT. Thank you very much for inviting me. Professor Arup Mitra has given a very good background of the entire issue, and I fully agree that there is not any strong relationship between the between labor legislation institutions and employment growth. He gave several examples, and that is why in World Bank surveys, this ease of doing business and all that, labor laws did not figure very prominently, or wage issue also, minimum wage, anything, no issue has been raised. Let me some initial remarks that this entire labor legislation institutions regime in India has been developed over 100 years, more than 100 years. In colonial period, like this trade union was passed in 1926, 1923. And this was the product of independence movement, ideology, and all that. And realization was that labor is a weaker partner in industrial relations system, and they needed justice. As Arup said that over the years in India, particularly in 1990s, trade union density and trade union power has further declined. Labor is defensive. So this is the background. But even then, what were the main criticisms of the labor laws regime in India? One was that, and that was quite fair, there are a number of facts. Just that 100, more than 100 legislations and 44 to be precise, so many regulations, multiplicity of definitions, category fusions, and all that. That is why it was a strong felt demand that there should be codification and simplification and rationalization. This has been a very fair criticism. The other has been criticism that which says that although de jure there is a labor rigidity in India, but de facto employers have been able to find ways with cooperation from government officials and all that. I'm not going into detail, and that is why they have enjoyed fair amount of flexibility. But it has led to informalization of work. This has been an important criticism of the existing labor legislation has been that it has created duality in the labor market. It has catered mainly to formal sector, and there are very few legislations like Minimum Wages Act and maternity benefits, and so some which cater to the unorganized sector. So the dualism between formal and informal sector has been sharpening, and the labor legislations don't do justice. Whether these the current labor reforms which have been undertaken, and which is by any standard a massive one, probably the most important ones after independence in the country. Whether they have achieved their objectives. First of all, let me say that there are some good things and there are some advantages. First of all, there is definitely some amount of consolidation of various labor laws, some simplification, although by no means perfect. So this should be first recognized. The second is, in wages, Minimum Wages Act of India 1948, there were so many confusions, so many schedules, it applied only to schedules and so many wage rates. So first of all, the wage codes will now apply to more sectors, more workers. A lot earlier, the Minimum Wages Act maybe covered around 40% of the workers. Various studies have shown. Now, there is no firm estimate. Of course, state governments have to formulate schemes and all that, but its coverage will increase. The third aspect is, for the first time, these codes facilitate the recognition of trade unions. So it may contribute to, I'm emphasizing may, to collective bargaining. And finally, in social security, I'm sure Ravi will have more thoughts on it. It tries to cover unorganized sector, but by no means perfect, and includes recognizing at least gig workers, platform workers, which is really a new category. But apart from that, as I said that the criticism was earlier that the earlier labor regimes, labor taxation regime, they cater to organized sector and increase the duality in the labor markets. So what will happen? It is very important that in various 4 codes, the thresholds, earlier also in the legislations there were thresholds. Now also there are thresholds, like EPF will be applicable in 20 or more workers, ESI 10 or more workers. But in some cases, threshold has been increased. Now for factory, earlier the threshold was 10 or more workers with power. Now it has been made 20 or more workers. So coverage of workers has been made more restrictive. Similarly, industrial safety, occupational safety and all that, also threshold has been increased. So my fear is that because of these thresholds and in several cases, increasing the thresholds, the duality in the labor market will further accentuate. So this is the danger. The other aspect, and which should be given due importance, is industrial democracy. Wages or any other benefit of the work democracy. Whether these codes, and industrial relations code is a relevant code in this regard, whether it caters to that. I don't know whether people have noted that industry definition has been made more restrictive. And now charitable organizations or those doing domestic surveys or philanthropies, they have been excluded from the industry. So big hospitals, big schools, colleges, universities, which are run by trust, they will be excluded from the industry definition and hence collective bargaining process. The other very important change which has happened and which will affect industrial democracy is that strikes now will become very, very difficult. now for any enterprise, any organization, 14 days notice has to be given. Earlier, only in case of public utilities, the 14 days strike notice was essential. Now this distinction between public utilities, water supply, electricity and all that, defense and all that, now that distinction has been removed. And no organization, no industry can go without any notice. The further restriction is that if there is a conciliation process going on, and in conciliation process, anybody can go, employer can go, trade unions can go, workers can go. So if it is under conciliation, a strike can't take place. Another important change is that, trade unions, workers used to resort to various tactics like mass casual leave. Now, if more than 50% of the casual workers take casual leave, it can invite disciplinary action. It will be turned illegal. So by all this, strikes, and a strike is all over the world is a very, very legitimate method of grievance redressal. And workers don't resort to a strike just for the sake of a strike. So this is one which will affect the industrial democracy. The other aspect is, and this introduction of fixed term employment. I know that there has been growth of contract workers, particularly in manufacturing industry, but in last 1 decade or so, or more than that, also in service industry. But now my fear is that there will be a gradual substitution of regular workers with fixed term employment. And this fixed term employment has not been defined. It can be 1 year, it can be 2 years, can be 3 years, and all that. So it will be a type of contract workers, except that, and this is an improvement, that they will be given same benefits, social security, wages and all that, which the regular workers are getting. But my fear is that over the years, it will be substituted. So one has to think whether in the country we need this kind of the uncertainty in livelihood which it will create, whether we need kinds of this. And of course, a very important change is the retrenchment provision that now firms up to 300 workers can retrench workers without government permission. And in fact, this was the most one act, Industrial Relations 1 clause, which was being demanded by employers' organization mostly. But I don't know what is the logic of 300 workers. Why not 500? What was the merit in 100 workers? Maybe, probably, and Arup will correct me, between 100 and 300, around 20% of all manufacturing workers firms probably are there, 20%. So what benefit it is going to give? I'm going to conclude in 2-3 minutes. So my feeling is that through all these, the duality in the labor market is going to further accentuate, and not that the distinction between formal and informal sector will narrow. Arup had pointed out about informalization process and all that. I think a very important policy in India has to be to bridging the gap between formal and informal sector. I don't see any provision which is going to bridge this gap. For informal sector, there are schemes, talk of schemes of social security. States will formulate DA schemes for gig workers, platform workers, and all that. But how it will be done, there is hardly any clarity. So to me, it seems that the entire this reform process is almost silent on this aspect, and my fear is that the distinction between the difference between formal and informal sector will further accentuate. With this, I stop, and I have taken more than time which was allotted to me. Sorry about that. And please to come, I will come in the question answer session. Thank you very much.
Thank you, Professor Sharma. Since you have raised this informal formal gap, and informal sector has featured in the last previous two talks, I'll just make a quick announcement to all the participants. Wider Finland, Wider Helsinki is doing a two-day workshop, in fact, on the informal sector. If anybody is interested, drop me an email. I'll send you the link to that. Okay, so that was for my Kunal Sen, who is the director of Wider. I promised him that I'll make this information available. So Ravi, over to you now. You are the one who started me thinking about all these issues.
You have to unmute yourself, Professor Srivastava.
Yeah, sorry. Yeah, thanks, Ajit. As you rightly pointed out, it was quite remarkable that the labor codes which were passed in Parliament without any discussion, and which affect almost each and every person in the economy, and certainly the entire working class in the country, were not discussed at all, except in some columns in the pink newspapers. And that too with a great deal of, basically thumping and clapping, because labor reforms had been on the agenda, or supposed to have been the agenda of mainstream economists and industry for a long time in India. So labor regulation, let me, I think Arup has covered a lot of ground, and so also Alakh. Let me just begin by reminding ourselves that labor regulation and labor policy is a very important instrument, both of social policy and economic policy. And the aim of, perhaps with the aim, and this is something of course can always be debated, with the aim of bringing about inclusive development and more equitable development. The question is whether this labor regulation and the labor policy, which it actually points towards, is going to lead towards more equitable development and more inclusive development. Alakh has said that it will not. So in the Arjun Sen-Gupta Commission, the NCUS of which I was a part, we had deliberated over it with many years, and a whole phalanx of colleagues were a part of this deliberation, as were organizations of workers and many others. And the conclusion that we reached was that what we needed in this country, in order to remove what labor market inequality, rising inequality, labor market duality, was actually a policy of what we call leveling up and social wages. Social wages constituted not just minimum wages, but it actually constituted making necessary essential public goods available to the working class in general. And this leveling up and social wages, of course, needed also to be accompanied by what we call universal social security. So social security was a major priority of this commission, and labor reforms. So we did talk about there was an extremely, I think, an outstanding report written under the chairpersonship of the late Dr. Popola on labor reforms, summed up in the last volume of the commission, where we talked about issues of rationalization, simplification of labor reforms, etc., considerable depth. So this is really, these are arguments which I think everybody accepts, the trade unions, the academia, and so on. And on this, there has not been much debate, but except that a consensus failed to emerge. Now, the basic argument, as again Alakh pointed out, and Arup also mentioned this, is this whole question of labor rigidity and the relationship of labor rigidity to employment growth, productivity growth, and so on in the economy. For a large number of years, this basic point has been made that Indian labor laws are very rigid, and that reforming these laws would lead to would have a number of implications, which was, and there were also adverse consequences of the fact that labor reforms were not being implemented. So the adverse consequences really was that there were threshold effects. The enterprise size in India was not growing, and there was a bunching below 20, and again between 50 and 99, so below 100 workers. This was allowing, and capital intensity was increasing, particularly in manufacturing. The Indian manufacturing was not competitive enough for that reason, and the quality of employment and the quantity of employment both were suffering. So in other words, if you had labor reforms, the basic argument was that you would relax all these constraints. You would make Indian economy, the Indian manufacturing particularly, will be able to achieve scale, labor intensity. There will be a growth in employment, the quantity of employment, and there would be also a corresponding growth in the quality of employment, because Indian industry was resorting to contractual labor and low quality labor to get around the problem of hiring workers whom it could not fire if they happened to be regular workers or could achieve permanence in the Indian workforce structure. This is the basic argument that was made. Now, this argument has been challenged by many people, many economists. Adit is in the audience, and I was hoping he would also speak among the panelists who did a lot of work on this. Professor Popola, who wrote a voluminous omnibus report on this whole issue, along with his colleagues. The commission itself, to which I referred to, Alakh's own work, and my own work in the last few years, categorically showed that indeed the premises on which these arguments were made were very weak. And we showed categorically, and I refer particularly to initially two papers of mine, one which I wrote for the ILO on non-standard employment. The other was my 2015 keynote paper, presidential paper in the Indian Society of Labor Economics, in both of which I showed how labor market flexibility was increasing instrumentally in the Indian economy. Labor market flexibility in the form of informality, but also in the form of its linkage to what the other problem that we recognize very well, which is increased labor market circulation, labor circulation, seasonal migration, and so on. And over a period of time, this had led to a cheapening of labor, but cheapening of labor was not the only issue at stake in achieving labor market flexibility. There was also the issue of gaining control over the labor process. So disciplining of the labor process was also a very important part of the strategy of using contract labor. And I argued for over a number of papers and in many papers and over a number of years that indeed contract labor was being trivialized because it was being thought only in terms of cost. But contract labor actually achieved a number of goals for industry, and that it would grow in any case in order to help industry and capital achieve many of these objectives. In later papers, I have also shown how there is a very strong link between increasing informality, migration, and growing labor market inequality, particularly in the organized sector of the economy. There are two other arguments which I just want to make, as a sort of opening arguments, empirical arguments. One is that the argument is often made that that Indian manufacturing and Indian organized industry is not able to increase or decrease the labor force in response to changes in demand or changes in macroeconomic conditions. And I've shown consistently that this is not the case. The employment in the organized sector of the economy tends to increase pro-cyclically and also decline pro-cyclically. I mean, to give you just an example, if you look at the NSS data, for example, and you look at recent changes if you look at growth in employment in India over the recent period, what you find is that between 2004-05 and 11-12, for example, if you look at establishments employing more than 20 workers, the growth rate in manufacturing employment in this high growth period, as per the NSS, was 5.5%, against an overall manufacturing growth of 2.2%. But in the period 2011-12 to 2018-19, when growth in manufacturing and overall employment increase collapsed, and overall employment increase in manufacturing was only about 1.1%, in establishments, manufacturing establishments with more than 20 workers, employment grew by only 0.9%. So in a period of high growth, larger establishment managed to have very high growth rates of employment. In a period of low growth, actually their employment growth was much lower than average. And over a period of time, I think the point that Alakh has made again needs to be reiterated. There was a very rapid informalization of employment in the formal sector of the economy. So if you look at the economy as a whole, and if you look at workers without any written contract in the economy, their percentages declined from 46% to 37% between 2004-05 and 18-19. And this happened both in services and in manufacturing. But interestingly, in manufacturing over the last few years, if you take the PLFS results of 2017-18 and 2018-19, there seems to have been an increase in the proportion of workers with formal contracts, with written contracts. And this seems to suggest that the composition of manufacturing within the manufacturing sector, there has been a change in the composition of industries who have contributed to growth. This may have been the result of demonetization, GST, all of which needs to be explored further. But I think issues out there, and if the empirical examination of these issues by several of us has constantly pointed out that the kind of assumptions which have been made by many economists in terms of the relationship between labor market flexibility or labor reform and the quantity and quality of employment and competitiveness actually do not hold. And as Alakh rightly pointed out, there are many other factors that we need to address. Now let me quickly get to this whole issue of labor reform in the manner in which it has taken place. First of all, Ajit, as you rightly pointed out, my own deep sense of disappointment that what the COVID crisis showed us in such manifest forms in the months of March, April, May, and June was the severity and the degree of precarity in the Indian economy. And that no step, except for some very superficial, meaningless steps being written without any implication in the courts, no serious step has been taken in the four courts to actually address the issue of rising precarity of the workforce in India. On the contrary, all the major steps that have been announced in terms of increasing the threshold limit for contract workers, interstate migrant workers, the threshold limit for standing orders, for the idea for retrenchment of workers, Factories Act, doubling of the threshold limits for Factories Act, and the introduction of the fixed term contract workers, all of them have gone in one direction, which is to increase the precarity of employment in the Indian economy. Now, this issue of what exactly have the courts done in terms of addressing the issue of quality? Two things. One, that there will be a national minimum, a floor level of wage. But as you know, more than a year has passed since the wage code was passed, and even the rules have been formulated, but there is complete silence on the national floor wage. And it is the national floor wage will become a benchmark wage for the country as a whole. So on that, there is complete silence. What runs like a thread through all the codes, whether it was required in a particular code or not, is the question of fixed term contract worker. So essentially, the basic design of the code seems to be to replace whatever kind of regularity or permanence that there is in the workforce with the so-called fixed term contract worker. Now, the fixed term contract worker effectively is different from the contract worker only in two significant ways. The fixed term contract worker will be on the rolls of the employer, whereas the contract worker is not on the rolls of the employer. Secondly, the fixed term contract worker, unlike the contract worker, will be entitled to two kinds of benefits which the contract worker is not entitled to. One is basically leave benefits. So it should be entitled to casual leave or any other form of leave which permanent workers are entitled to. Secondly, if for those employed for a year or more, they will be entitled to pro rata gratuity. All the other things that are talked about in the codes, for example, equal wages for equal pay, and so on and so forth, these are part and parcel of everything else. So the contract workers are also supposed to get the same level of wages as other workers. So this is not really an issue which merits attention. The basic limitation of all the four codes, other than the fact that they do not address the issue of precarity, or rather that they increase it, is that the codes are limited to what they do for organized sector workers. And here, of course, they raise thresholds. There is very little other than the wage code where anything concrete is done for unorganized sector workers. So much so that there is virtually nothing in the remaining three codes which governs the conditions of work of unorganized sector workers who, as we know, form 4/5 of the workforce, more than 4/5 of the workforce in this country. And as Alakh has pointed out, the codes already, the bargaining strength of the working class in India has shrunk to something unrecognizable because of the increase in fragmentation, increase in precarity, increase in formality, and increase in segmentation of the workforce. And the courts have taken a number of steps to further decrease the bargaining strength of the worker, particularly the IR code, which already Alakh has referred to. And finally, inspection, which is a critical part of any labor regulation mechanism, has been reduced to a sham. Because inspections can not only happen through a computerized lottery, which means in any case, only organized sector establishments will be part of any inspection mechanism. Complaints-based mechanisms of inspection are ruled out. There is no modality of inspection as far as informal sector is concerned, because the informal sector cannot be inspected on a basis of a lottery drawn on establishments which will be above a certain threshold size. So essentially, the codes militate against the unorganized sector. The Social Security Code has no tangible, it does not offer anything tangible to the unorganized sector. They increase the level of precarity, and as such, we become one of the few countries globally where policy does not address the issue of inequality, and where labor market policy has not even begun to address the issue of informality. Because if you look at most countries, whether it's Brazil, whether it is China, in fact, Vietnam, these are the countries to which the pink press often tends to compare us with. All of them have more sensible labor policies, have moved towards formalization. Their fixed-term workers are workers who cannot indefinitely be kept on a tight leash. the rights do accrue to them over a period of time. None of that has been built into the code. So unfortunately, the codes are preparing the way to, as I had called also in my article, a race to the bottom. And I don't see the code addressing issues either of growth and employment, which in any case require multiple levers, or issues of equity, social justice, and inclusive growth. Thanks a lot.
Thank you, Ravi. Professor Shyam Sundar, you'll have to unmute yourself. Okay.
I have the PPT. How do I share? I'm sorry, I'm technologically.
Can you see a button, share screen, green button at the end, towards the bottom? There is a share screen button in your computer, and you can't.
At
Yeah,
the
I
bottom.
have a share screen. Yes.
Yeah. So just click on that.
Click on that.
Yeah.
Yeah. Here we go.
Yeah. Basically, the argument that I'll be making, I didn't know that Professor Arup will also be doing the introduction, where he has stolen quite a few of my figures and tables. Nonetheless, I have what I have. The thing is, the labor market reforms in India, it's a wrong argument, hence led to wrong labor law reforms, and that too during wrong time, which is COVID-19. This is what is my core idea. Before I start making the presentation, a couple of opening statements. I would like to say that we should generally avoid using the term labor reforms. I don't think labor, or as a worker or working class, has anything to be reformed. It may be labor market reform or labor law reforms, or like capital market reforms and things like that. So, so I would like to use the term labor market reforms, which has two components. One is a substantive component, of which my previous speaker spoke of, the labor flexibility, wage flexibility, and all those things, all those aspects, and then the procedural aspects, which largely concern the labor inspection system, which Ravi also spoke of, and of course the labor administrative system, wherein the employers are required to maintain records, submit annual or quarterly or half-yearly returns. So these are procedural aspects. So the labor market reforms is an umbrella term covering the substantive as well as the procedural aspects. Now there are two comments that I wish to make on Professor Arup Mitra's presentation. One is that if elasticity of employment with respect to real wages or the cost, labor cost not being a primary concern for the employers, why do the labor law reforms occur? It occurs primarily to shift the labor, to dilute the labor market power, as Ravi has argued, in favor of the employers, and to commodify their labor market further and further. And secondly, it is not only the domestic firms which have resorted to sly labor flexibility, it is the multinational firms also have been on the forefront, like Hyundai, Maruti Suzuki, etc. Now let me come to my slides. So basically, we all know the argument that labor laws are rigid and labor inspection systems are tough, and thereby they really hurt the working of the free market economy. And it hurts the ease of doing business. And the countries which are benchmarked, which is a serious concern, is Bangladesh, Vietnam, China, Cambodia, etc. And India loses as against them. And the new argument that has been advanced during the COVID, because of the notoriety that China acquired as a result of COVID origin country, the space vacated by China must be occupied by India in terms of three aspects: A, the trade aspect; B, the foreign direct investment; and C, the capture the contracts of the global supply chains. And if we do not do the reforms in time, which we have taken according to the labor minister, 70 years we have conducted social dialogue, but it had not led to reforms. So this will reduce foreign direct investment, affect employment generation, and according to Basole and Burgess and et al., it will affect poverty alleviation. So the political economic argument is that the very labor institutions, which include labor laws, trade unions, collective bargaining, etc., which are intended to promote, protect and promote labor welfare, are the villains. They do not promote labor welfare, they hurt labor welfare. So they entirely twist the argument to put it or put the blame in front of the doors of the labor institutions. So the reforms are necessary. Of course, they cite the considerable jump that India had maneuvered to achieve in terms of better rankings in the World Bank Ease of Doing Business, which anyway is under credibility crisis. So the major law reforms, since Ravi and Professor Alakh Sharma have covered, I would not go into the details, but I would like to mention that these reforms have been taken place on an aggressive spree ever since the National Democratic Alliance government came to power in 2014, and under Prime Minister Mr. Narendra Modi's leadership, Rajasthan kickstarted the whole process in the month of September 2014, and then it followed. Now, the problem with the labor law reforms is that they say that the labor law reforms will promote employment, which for them is numbers, the quantity and not the quality, as Ravi mentioned. And secondly, the labor law reforms have been introduced. Considerable flexibility has been given to employers without corresponding social protection, of which Ravi has written a wonderful paper for ILO. I think it is in 2013, 2013-14. And the social protection floors are not even covered by India, of which someone in the query that was sent by the director, it was there. There is no unemployment insurance scheme excepting under the ESI Act, which I will show you. And they have maintained the low severance benefits. And reskilling is a damn spirit. And if we went by the story that appeared in Business Standard, the whole idea of the government when they give either the unemployment dole or the reskilling fund is based on basic mistrust on the worker. The Business Standard story said that the reskilling fund will be, allowance will be 15 days of average of pay, which the worker should demonstrate to have used that money for reskilling himself or herself on a paltry amount and produce certificates. Thereby the worker will be eligible to be re-employed by some other firms. The entire labor market reforms or the governance is based on three kinds of trust deficits. Number one, workers shirk. So raising the cost of unemployment will reduce the shirking behavior. Secondly, workers will have to produce evidence so that they can claim unemployment allowance or skilling allowance. Number three, inspectors are rent-seeking agencies, so inspectors cannot be trusted. So in other words, and of course, collective bargaining is a kind of a collusionary arrangement with the employer in order to derive rents and earn monopoly wages. So the whole argument is based on these kind of trust deficit economic arguments. So let me go and to some of the tables that people might be knowing. We know very well that informality and precarity are the two defining features of labor market. We see that the informality rates are very high in non-manufacturing, which is construction basically, driven by construction. And in manufacturing, it's about 85%. And we also calculated compound average growth rate. We see that the real wage growth rate since 2000, in 2000-2005, it was negative actually. In 2006-10, it was respectable 2.76. That was the UPA 1 period. And then 2011 to 18, the real wage growth has declined to 1. That is, the rate of growth of real wages has declined from 2.76 to 1.72. And correspondingly, the rate of growth of establishment of factories also has declined from a high of 6.15 to 2.56. And has Professor Arup Mitra has shown that the share of wages in the gross value added has declined from nearly 27% in 1982-83 to 12.68%, though there has been a tendency to rise from 2009-10 onwards. And the share of contract workers, which is an official ASI estimate, which is an underestimate, any trade union will be able to tell you, more than 1/3 of total workers in the organized factory sector is contract workers. But why are the industrialization reforms taken place? Why have they taken place? Why should the labor power should be reduced? Is there evidence of it? I mean, we have the two graphs here which shows that on an average, the share of workdays lost due to lockouts has been 2/3. If 100 workdays are lost due to total work stoppages, that is strikes or lockouts, 2/3 are due to lockouts. So employer militancy, lockout is a manifestation of employer militancy, apart from retrenchment, closure, dismissals, transfers, etc. We don't have data on those. And the frequency of strikes, the number of times trade unions have called a strike, has shown a secular decline in the post-reform period. And then I also calculated the average duration of a typical strike and a typical lockout. We see that over the period, the average duration of lockouts has increased from 43 days in 92-95 to 134 days in 2008-10. So lockouts will typically last longer, and Professor Radha, who passed away, who was the ex-ISLE conference president, in his book he has shown that lockouts are actually closures in disguise. Longer lockouts degenerate into closures, partial or otherwise. Then we also had this tyranny of Inspector Raj pronounced by Dr. Manmohan Singh. I could imagine if it was done by Mr. Narendra Modi. Dr. Manmohan Singh, in his address to the Indian Labour Conference, said that the tyranny of labor inspection Raj should decrease. I have taken the factory inspections in West Bengal, the communist state at that time. It has declined steeply. And then I have taken the inspections and prosecutions in the central sphere, where the central government is appropriate government, where central government is supposed to be much more efficient than the state governments. They also have shown a decline. Then I also looked at Maharashtra. I looked at the average rate of prosecution under all labor laws during 1987-88 to 2012-13, and employers can generally say that we are prosecuted, and then we have a lot of legal transaction costs, etc. The prosecutions have declined over a period. And then I also looked at is there any reform on the industrial dispute settlement side? The average pending cases with various labor courts and industrial courts have shown an increase. They are far higher. On an average, 18,322 cases are pending in various courts. So the industrial justice is denied, and they take a long number of years, months and years. They stagnate in the labor court. Then they go to the High Court under Article 226, and then special appeal to the Supreme Court under Article 32 and 136. And then I spoke about the unemployment insurance. We have a very narrow unemployment insurance schemes to those workers who are covered under the Employee State Insurance Act. These are the absolute numbers of workers who have made claims of unemployment insurance over the years 2007-8 to 2017-18. You will all be surprised to see that only 872 workers in a year have made availed the unemployment insurance scheme that is given by the government. So even, and the Industrial Relations Code does not speak of unemployment insurance, I mean Social Security Code, sorry, even though it is contained in the definition of Social Security as per the ILO Convention on Social Security and Miscellaneous Provisions. And the Labour Ministry deposed before the Parliamentary Standing Committee, and they told the Parliamentary Standing Committee, before which I also deposed, that ESI scheme, unemployment allowance scheme, will take care of the unemployment in the organized sector, and the social protection given in the Social Security Code will take care of the unemployment arising in the unorganized sector. I'll leave it to Ravi to comment on this any further. And then India in fact has ratified very important conventions on Labor Inspection Convention, Tripartite Consultation Conventions, and Employment Policy Convention. The Tripartite Consultation Convention requires the Indian government, the ratifying country, to hold social dialogue with the social partners before framing labor laws or framing economic and labor policies. But we see that the social dialogue in India has weakened over the period, and from 2015 onwards, the Indian Labour Conference, which is a tripartite social dialogue body, has not met at all. Now, in the post-reform period, due to paucity of time, I am not getting into the political economy, the G2B has become dominant, and there is an aggressive and impatient state which is wanting to introduce labour market reforms without any social dialogue, effective social dialogue. I mean, I need to qualify social dialogue as effective social dialogue. It has not taken place. So there are considerable voice deficits, which leads to unsound industrial relations, industrial violence, strife, no cooperation, and low productive efficiency. So at the end of the day, we have two types of labor market governance. One, the neoliberal labor market governance, which relies on low cost model, labor flexibility model. And on the other hand, we have the decent work model or the institutional model as enunciated in the ILO conventions, and also by institutional economists from Derry, Rogers and others. So between these two models, India has opted to prefer and resort to neoliberal argument, notwithstanding the fact that there is not enough evidence, as Professor Arup Mitra has given, and Professor Aditya Bhattacharya, I am told, is there among the people who are here. And so India has chosen a wrong strategy, and it would pay dearly in terms of adverse social outcomes of proliferation of informal jobs, precarious jobs, poverty enhancement, and I'm more interested in the development of human capital for the future. With a low level of real wages, how can contract workers, fixed workers provide for creating a new generation of people who are well-fed, nutritious, well-educated, well-skilled, so that the labor market in the 2040s will have healthy, skilled workforce. And that is my gravest concern, and that will be the, probably, God forbid, the social outcome. Thanks very much.
Thank you, Professor. Okay. Thank you very much. That's a very, very strong and clear statement. Now, Amit.
Yeah, thank you.
We decided to give you a long break. Okay.
Thank you. Actually, I was saying just privately to Mausumi that a lot of the points have already been made. In fact, there's very little for me to add. You know, these have all been excellent, and these are all people who are much more knowledgeable than me. So I feel actually quite reluctant to say much. I'll keep it brief. I have prepared 2 or 3 slides as a summary of my thoughts, more so that I stick to the point. So I'm just sharing that. And I think most people will realize it is more or less my attempt to kind of bring together most of the arguments. In fact, I was editing the slides even as other speakers were speaking. So let me just say my piece, and then we can go into questions. So I've been thinking about this more or less on 3 dimensions, welfare, equity, and efficiency. And I would like to start from the premise that the existing situation before the reforms, before the latest round of these code rationalization, etc., was already poor on all 3 fronts. Meaning we were not getting what we should get either in welfare or in equity or in efficiency terms. Let me briefly elaborate. So by welfare, I mean some basic social security, wage and safety floor that is irrespective of the employment arrangement. What has been called the universal social protection floor also, which does not exist. So the basic welfare part is not met pre-reforms. Equity, by which I mean what is the distribution of protection and benefits which given scarce state capacity, the capacity of the state, which includes the central and the state governments and so forth, and the various institutions to enforce the laws that exist on the book is of course limited. And given that, where is it spent? Where are these resources spent? Can we have a more equal distribution of protection and benefits than we've had so far? This is usually thought of as the dual labor market problem which was referred to. The third dimension, which is efficiency, and this is of course where most of the mainstream arguments come, that we want scaling up of dwarf firms, or firms should not remain dwarfs, which would lead to higher productivity. Now monitoring and enforcement costs also would scale down as firms grow in size, because these costs scale poorly down, right? The more number of smaller firms you have, the more costly it is to enforce laws per firm. So increasing average firm size actually makes enforcement cheaper. So scale up can improve productivity through technology adoption, but scale up can also improve productivity via improvement in working conditions, reduce turnover in principle. I'm not saying that all of this actually happens with scale up, but this is the argument. So the current, what do the current reforms do in respect to these 3 dimensions? As I said before this, we were not doing well on any of them. We didn't have a basic security floor. Protection is distributed very unequally. And of course, our scale of production is very small, as everybody knows. The current reforms do not improve 1 and 2. They probably make them worse. And we've already heard that before, so I won't belabor that too much. On 3, time will tell. I mean, the whole argument is pinned on scale up. And as Professor Shamsundar said, also there are many other factors that come into play here. So it's not by any means guaranteed, but time will tell what will happen. Now, just to spend a minute more on this rationale, again, mostly just summarizing what people have said. The basic rationale going into the reforms is of course to reduce compliance costs, thereby to increase firm size as well as profitability, which would increase employment and tighten the labor markets, which is in this kind of way of looking at the world, the best protection that you can offer a worker, a tight labor market. Or to flip it the other way around, in the absence of a tight labor market or with very loose labor markets and surplus labor, no amount of legislating improves working conditions. That is the, just baldly stated, the position. But of course, there are many caveats to this argument. As far as small and medium enterprises are concerned, labor regulations are one very likely a very small part of compliance costs. Right? There is a well-established culture of mistrust in many parts of the country between the states and entrepreneurs that still persists. Despite the fact that we usually view the state as pro-capital, I think there is some nuance here in terms of what capital really means, when we look at the complex landscape of firms. There may be crony capitalism, there may be a lot of pro-capital lobbying that goes on that does not necessarily translate into all kinds of entrepreneurs everywhere, and particularly does not translate into the SME segment. So labor regulations are likely one part of compliance costs. They're probably a small part, and compliance in general is a likely small part of constraints on growth. So there are these, sort of labor laws are a small percentage of a small percentage, if you think of barriers to growth. I'll maybe briefly allude to what these other constraints are, although they are mostly very well known. Related to the scale-up point, one has to notice that actually growth elasticity of employment which is already low in many places, reduces with firm size because of the increased adoption of technology and automation. So there's a trade-off between higher productivity gains due to scale up versus a lower employment elasticity. Right? So is there a sweet spot here? That is the question when we talk about scaling up of firm size in India. In terms of the trade-off being between gains to be had from higher productivity, which would hopefully also translate into obviously better working conditions. Again, by no means given. This is the bargaining power issue. That on the one hand versus weakened capacity for job creation among larger firms on the other hand. Now, the result of this kind of a reform, the process that we have seen, which as I said, doesn't take us very far on 1 and 2, on welfare and equity, in fact might make things worse on both those fronts. And with efficiency, there are all these caveats that I've just mentioned. The question is, will the result be net losses for workers with no net gains for the economy? And I think most of the previous speakers seem to be leaning towards this position, and we can return to this in the Q&A. Lastly, what is the way ahead on each of these issues? And here again, I don't have too much to add. It's all been said before many times. On welfare, we have to move towards what could be a low but enforceable universal basic social security floor. There is a trade-off here again between enforceability and how high the floor is. So there's not much point as far as I'm concerned on having a lot of well-intentioned laws which we are not able to enforce. I do think that there is merit in this position. So we need to think seriously about what is an enforceable floor. This is of course bypassed in the present codes completely, so there's nothing they have to say about it. On equity, it's true that we may have to be prepared for a loss of protection and benefits in some segments, given scarce enforcement capacity again. So leveling up, yes, definitely. Can that leveling up happen? So an average level of leveling up, so to speak, can that happen with no loss of protection and benefits in any segment? I don't know. I wouldn't be surprised if that is not possible. But an overall increased level of protection all around with some loss in the higher segment is perhaps a possibility. Of course, the current round makes it worse for some without making it better for others. So it's not really improving the average level in this case. Lastly, on the efficiency point, I just want to add a few caveats to what has been said with respect to the actually existing compliance structure. The mismatch between what the Indian state says it wants to do as far as laws and inspections and so forth, and what actually happens on the ground. Now, of course, it is quite true, as Professor Sundar also has shown a lot of data, that inspections do not occur as they are supposed to, and many other kinds of compliances actually do not happen. But that, even if that is the case, the costs more function of what is actually being implemented with the laws. Laws can be used arbitrarily, for example. They can be used as a stick to beat employers with, where inspections do not occur, but the threat of inspections is there, which is used for extracting surplus. Perceptions among employers do play a role. Again, in the SME segment, this is more important, where employers just don't scale up because they have some sort of a vague notion that my costs are going to go up quite a bit, whether they in fact go up or not. So that makes the issue complicated. What And I think this is also partly what is going on in the labor laws case as well. It is on the backs of the SMEs that laws are weakened, but the advantage of the weak laws largely accrues to the larger players and not to the SMEs. Finally, what is always going to be the case, that as I said earlier, labor regulation and compliance costs, well, okay, by all means reduce them. If you can do it while increasing the average level of protection and a good floor, non-negotiable floor. But if you don't lift other bottlenecks, particularly infrastructural and others, then really it's not very realistic to expect this particular kind of reform to have much effect, either in efficiency terms or on employment generation terms. So you will lose out on welfare and equity fronts. You won't gain on the efficiency front, resulting in a situation that really benefits some employers in some sectors, as we have seen, but largely is a net loss for the economy. So I'll stop here.
Thank you, Amit. Thank you very much. Very, very, very clear. Okay, so now what I'm going to do is we got 30 minutes, okay? Since I was enjoying listening to you all, I was kind of not very strict about the time. So we've got about 30 minutes of Q&A. So what we're going to do is we're going to unmute the person asking the question, and they can ask the question themselves. So that's easier than me reading out and trying to misinterpret. Professor Manas Panda, you have a quick question, I believe.
Yeah, I have a very quick question.
Yeah.
The new category of fixed term employment, will it affect more the organized sector, or there is a possibility that some of the contract labor also might be employed in that category? In that case, there might be, at least for that segment, there might be a labor welfare implication. Hello?
Yeah.
No, you could hear, no?
Yeah, we could detail. Is it specific to anybody?
I think basically Professor Alakh Sharma and Professor Srivastava, both of them covered this point.
Can I
Did you get the question?
Can I come in?
No, you are telling about the fixed term employment.
Yeah.
Now the question is, if if this is going to be a major segment, if it is insignificant, then of course it doesn't matter. But if it is going to be a somewhat significant segment, will it affect more the normal employment in the organized sector, organized labor, or the contract labor?
I think it will affect certainly organized sector only, because in unorganized sector, there is complete flexibility, whether you imply daily wage labor or contract labor or regular workers. So unorganized sector, it won't pertain to only in organized sector. And as I said in my presentation, right now, employers have been substituting, particularly in manufacturing sector, but also in now you see in even in government sector, contract workers. So what will happen that, of course, contract workers were in organized manufacturing not employed by the industry directly, but by the contractors. So to that extent, it is an improvement. They will be given same wages and all that. But my hunch is that it will become like contract workers, and its category is going to increase substantially. Who will hire? Because, wages is one aspect, but control over labor process. Employer want to control labor, want to make them disciplined. So through this category, why will they have a regular workers? They will employ for 1 year, 2 years, 3 years of their discretion. In some other countries also, this kinds of provision is there. But most of the countries, if they are for certain period, they become regular. The other aspect is that, when the nature of the work is regular, why should employer employ a fixed worker? So I think this is going to be a flexible category of workers whose numbers will, I fear, going to increase substantially, like contract labor, what has happened in the past.
Do you want to add anything, Ravi, or we'll move on?
I mean, I think Alakh has answered most of it. The simple thing is that fixed-term contract workers at the moment are only relevant for manufacturing because the category had already been introduced through notification as far as services is concerned, and for central sector establishments also it had been introduced through notification in 2018. In manufacturing, it is much more likely to replace the existing categories of regular or quasi-permanent workers rather than contract workers. Although it may reduce contract workers by a percentage or two, but the major impact is going to be on any degree of permanence which accrues to workers, and therefore their ability to take advantage of various provisions of the Industrial Dispute Act and so on. That's where the major impact will be.
Could I, Professor Mishra, could I just ask,
sure,
I actually have a question about this, and I was speaking to Professor Shyam Sundar the other day. So it just did not make any sense to me, the introduction of this category without saying anything about the outlawing of existing contractual system. I mean, this was, what is the point from the point of view of the employer? What is the point of having a fixed term employee on the books with benefits when you can do the same thing through the contract system as you do now? I just couldn't understand that. So if perhaps somebody could comment on this.
Yeah, so I mean, under the existing standing orders and the ID Act, workers who have been on the rolls of the firm for more than 240 days a year, they acquire certain rights, both in terms of the ID Act as well as, and they get classified differently also under the Standing Orders Act. Now, if you introduce a category of fixed term workers, that is the government thinking, and I don't think this is, because obviously permanence also has to do a great deal with on-the-job learning, growth, training, internalization, and all that. I don't think the governments have thought through all of this, but their argument is that if you introduce this category of fixed term workers as a substitute for this category of workers for whom certain rights accrue over a period of time, then you will phase out that category of work. That ultimately has to lead out to a phasing of those category of workers in the long term. And therefore all the incremental rights, and these are mainly labor rights, because gratuity also, because the whole question of career progression gets lost with fixed term contract workers, also internalization of training, capacity building and all that. But those are the negative sides. As far as the government is concerned, it's mainly because of, and the employers are concerned. So they're introducing this category. Because it is limited to the category of workers in the private manufacturing. So it's not a very large category of workers. In services, we already have this category. So that is something that we have to understand. But now they've introduced it across the board for all sectors. This category is going to be there, and ultimately the only job it can do is to replace permanent workers.
Can I just add a few lines?
Sure.
Yeah. See, there has been a strong criticism about the fact that the contractual workers are being continuously exploited by the contractors. Even when the mother organization pays the minimum wage, it is actually not disbursed to the workers. So there has been a lot of writing on this particular aspect. I think from this point of view, the government is trying to empower the employer to engage workers on temporary basis. So in other words, in IEG, for example, instead of having the contractual laborers, IEG can actually employ these boys for 2 years or 3 years and without actually giving them all the retirement benefits and things like that. So I think it tries to overcome the disadvantages associated with the contractual employment.
So for a well-meaning employer who doesn't want to make a choice between a permanent employee on the rolls and exploitative contract labor, it offers a third option.
For middle one. Okay, thank you. Sabyasachi, you have a quick question, I believe.
Yes, yes. Hello. Can you hear me, sir?
Yes, we can hear you very loud and clear.
Okay. Actually, I have a question to Professor Mitra. That is there any law to control intermediaries who is actually in between the formal and informal sector, the intermediaries? So, do we have any law to control them so that the exploitation of informal sector can be reduced?
Yeah, I got your question. In fact, that is what I was trying to harp on. I was saying that this particular point has been completely missed out in the entire process of labor reforms. You have a great deal of linkages existing between the formal and the informal sector. But unfortunately, the business contractors, the labor contractors, they play a significant role. And in the present process of labor reforms, you do not have any space to overcome these problems. That is what I was trying to say, that the business contractors will continue to exploit the informal sector workers. And the other point that I was trying to highlight is that you don't have any strategy to improve the labor productivity in the unorganized sector. I think the most important issue in the unorganized sector is that we have very low labor productivity. So if a large part of the labor productivity is transferred to the workers, then a very small share is retained with the entrepreneurs. So further investment, further growth is almost impossible. And the third aspect that I was trying to say, that the social security code, it is completely vague. It only says that if you have employed me for last 15 days, you will have to contribute for my retrenchment and for my reskilling. But what about the other stakeholders? That if you have employed me for 15 days and if you are going to contribute a small amount for my reskilling, that is not going to be sufficient. What else will need to be done? So there they say that the government will come up with various schemes. When and after what period?
Thank you.
Thank you.
Just one second, just to add to this, Ajit. Scale actually no longer resides in production. It actually resides now in capital. Particularly if you look at global value chains and so on, which is why this whole notion of having a threshold effect to define the size of capital and employee capacity is now actually basically an archaic notion. And which is why we had to move towards removing duality from a bottoms-up approach.
Shyam, do you want to add to that? Because you were talking about productivity, human capital towards the end of your presentation.
Was that for Professor Shyam Sundar or me?
Yeah, Professor Shyam Sundar. Yeah.
Yeah.
Open to you, Amit, also, if you want to add.
No, that's okay.
Okay.
You are muted, Professor Shyam Sundar.
No, I would have said the same thing what Ravi has said now.
Okay, so I want we've got quite a few questions now. I would like you to be a bit brief and precise on your questions so that we can take views from the panelists. Next, we'll take one from Professor Beena Naragal. I had shared her questions with the panelists before, and then after that, Professor Prabhakar Sahu. Professor, you are unmuted.
Yeah. Yeah, I think I'm unmuted.
Yeah.
And am I audible?
Yeah, you are. Yeah.
Yeah. Thanks, Professor Mishra. I mean, it's been great listening to such a high-powered panel. I, as a non-economist, of many of you all very, very closely. I just have two sets of concerns, and I would like to sort of hear your views on it. One, of course, being the fact that the labor bills were, preceded the passing of the agriculture reform bills. And it seems to me that, and I'm sure it's evident to everybody else as well, that, both have outcomes that are, interrelated. But, you know, I mean, this is something that we haven't actually sort of, the connections and the overlaps and so on, and the dangers and the consequences have not been sort of actually, the dots have not been joined at all in any of the commentary that one has read so far. I know various people who did surveys, including Amit's, Basole's work, you know, the report that you all put out from APU on livelihoods and so on. I mean, that actually did look at both urban and rural livelihoods and so on. So I'm just wondering if any of the panelists can offer preliminary reflections on how we could read the agriculture and labor reforms together. That is one set of concerns. And maybe I'll leave it there because that might allow the panelists to actually sort of, you know, offer a round of comments.
Okay, thank you. Ravi, you start. You look like you are.
No, I'll briefly come in because instead of waiting for somebody else to, no, just to say that I think the underlying thread in my view, in a number of policy changes that we have seen over the last few years, beginning with demonetization, is really a shift in favor of a large-scale industrial and financial capital, both national and global. And to me, that is a very consistent shift, whether one looks at demonetization, whether one looks at GST, whether one looks at the agricultural reforms, or whether one looks at labor reforms. The question is whether that kind of shift at policy shift can produce the kind of results that we want for the economy and the direction. It's not new. I don't think that the shift is new, but I think that there is a very marked shift, and it's also there is a very marked shift in the manner in which the changes have been implemented in the last 4 or 5 days. So that is my succinct answer to that question.
Okay, no, very clear.
I'll just make one small addition. I think I agree entirely with Professor Srivastava, and you know, again, this is very speculative. I think we can all only speculate on this, but it seems that the government is trying very hard for a lot of these sort of textbook checkbox things on factor market reforms, one by one. But it also seems that it is really unwilling to take on any of the hard political economy constraints that exist, or very long-lasting legacy issues like infrastructural bottlenecks and so on, unless you are a very big player. I mean, if you are Adani or Ambani, probably doesn't matter to you too much. But for pretty much any other employer, these things matter, and there we don't seem to be doing much. So I think there's a sort of weird loop we are stuck in, where we think that just doing these, checking these boxes is somehow going to deliver us some Chinese level of performance, when we are not willing to do many of the really hard things, whether it's building a culture of trust, whether it is delivering reliable infrastructure. We don't do anything there. And that is not a flick of the pen kind of a reform. It requires much harder work, and I don't know. I mean, obviously, I don't have the answer to this, but it's just an observation.
Well, I'm audible, right?
Yeah, you're on mute.
Yeah. All these reforms are premised on 2 false promises. One is that access to market will empower and increase benefits to the economic agents, particularly the small, whether they are in agrarian sector or non-agrarian sector. Access to market will benefit, and the thing that Amit said, that Arup said that the cost of low productivity will no longer be borne by the employer, but it will be borne by the system. And the second one is that the more choices that are given to the employers or the farmers, greater will be the efficient and equitable outcome in the system. These are the 2 premises that I see in cutting through the form as well as non-form bills. Thank you.
Thank you. Okay, the next one, Professor Prabhakar Sahu has a comment question. Prabhakar, can you unmute yourself?
Yeah, thank you, Professor Mishra. I think it's a great panel. excellent points, and I'm grateful actually. It was a learning process for all of us, I'm sure. Can I just make few points quickly to everybody? I'll take 2 minutes.
Okay.
The first point actually, Professor Mitra made very good points. In fact, I didn't know so many things about the refunds. It was useful. But one of the points he made that, multiple labor laws or rules or rigid labor laws were not responsible for sluggish employment growth. I really don't know whether it is something to feel good about it. And I don't agree because if you just look at China, they implemented labor market reforms in '95 and successive recommendations or amendments took place. And the same thing also has been replicated by Bangladesh, Vietnam, Mexico, and you know the results. The initial 2 decades, China has been successful because of the reforms. The labor-intensive, the FDI in labor-intensive sector, particularly export-oriented labor-intensive sector, one of the main reasons what happened for first 2 decades in China, that is happening in Bangladesh now and Vietnam now. So all these rigid labor rules or regulations, if not rigid actually, what you call multiple rules, they were responsible for sluggish employment growth. Just look at some of the indicators. Capital intensity in Indian industries is one of the highest among the developing countries. FDI comes to India in either service sector or capital intensive sector. We are exporting, being a labor surplus country, we are exporting capital intensive exports. Economic survey has brought out. So I think these labor reforms are required and they were responsible for sluggish employment growth. There are phases where we had good employment growth, but that was growth impact. Few small points for Professor Sharma. It is about not allowing casual leave is undemocratic. I do agree with that. But Trade Union Act doesn't allow, or rather it allows anybody can be the office bearer. So people from political parties, they are holding offices in trade unions, and sometimes they go for number of the strikes and all that without having genuine reasons. So I think that is necessary. And fixed term employment. Look, Indian business, they go through business cycles. It is sometimes seasonal. So fixed term employment, which is a better version of contractual employment, as far as I understand, I think it's a better option. And now the question about 100 to 300, what is the logic, or is it an arbitrary number? Look, Rajasthan has done it. It is just a step forward to scale up. 100 to 200. The moment you do that, most of the firms, those are employing 100, now they can go to 300. And some of the labor rules and regulations are not applicable to them. I think some of the weak, some of the outcomes, though it is weak, it shows that there is a positive result from Rajasthan. Professor Srivastava, it's about, that labor reforms, if I understood right, Professor Srivastava made a point that we are referring Bangladesh, Vietnam as the case studies to go for this kind of reforms, but they give better benefits. As far as I have read, I don't think their labor reforms do give great benefits. Maybe the similar 90 days payout and all that. So I don't think, and then his argument was these labor codes which have been passed by the parliament, they don't talk about unorganized sector. I fail to understand why should they really talk about unorganized. Anyway, these codes are only applicable to the organized sector. Now, Professor Sundar, you see, my point is reskilling is not possible with the limited government sources, or you don't expect Indian farms to do it. They are kind of they follow the shortcut and they don't do the minimum thing. I feel the best way to do is, along with the labor reforms, introduce vocational training in large scale. Like China has done, 47% of all the students enrolled at secondary level are given vocational training versus 2 to 3% in Indian case. I think that is the way to go so that we make our labor force employable with the changing conditions. And then about the point, I completely agree that number of strikes, the mandates lost or cases pending, they have been slowing down. In fact, our labor force has been very cooperative. They understand the market conditions. Then the question is, if I understood right, you put a question, should we go for labor reforms? Should we justify that? No. See, the point is the investors, whether it's domestic and more so, foreign investors, they believe or they live in a legalistic society. So as long as these labor rules and regulations are there, even on paper, even if our labor force is kind of very cooperative, they will not invest billions of dollars in labor intensive manufacturing, which we badly need to reap the benefit, what is called demographic dividend. And then one small point, last point, I'm sorry I've taken more time. Professor Amit, your point, if again, because I don't work on labor issues or labor markets, is that the compliance cost, the justification for reforms is like, it will reduce the compliance cost. But your point is compliance cost is very low anyway. In MSME sector, 90% of the farms, those who are tiny and small, they don't have more than 100 workers. Most of the labor law is not applicable, by the way. So compliance cost is low, but that does not tell us that we should not go for reforms. That's my point. Sorry, I have taken more time.
Well, yes, but yeah, they were good questions. So but now I will invite the panel to respond. If you have remembered your question.
Can I respond? Nominal question.
Arup, we can't see you. Can you switch on your video? So it's a little.
Switch on my video?
Yeah, please.
Yes. Yes.
Okay, good.
When I said that labor laws were not actually responsible for sluggish employment growth during the 80s and even during the 70s or 90s, what I meant that the Indian entrepreneurs were clever enough to bypass all those strict regulations. They knew the art of the game, and hence there was no decline in employment because of strict regulations. They knew how to sort of play with these regulations, and they could go ahead with the retrenchment that they wanted. So the retrenchment was not attributed to the strict regulations. That is what I wanted to say. Yes, of course, you are right that when it comes to the FDI, it has been a great hindrance. The labor laws have been a great hindrance. And the foreign investors are not really aware of these secrets, and hence their employment growth in these FDI units has been extremely low. I do agree with that. Now, finally, when you say that capital labor ratio in the Indian context has been increasing steadily, and this is purely because of the strict labor laws, no, not at all. You look at the literature, what it is trying to suggest that the entire process of innovation, the kind of technology that is being developed, it is highly, highly capital intensive. Even if you, the idea is that even if you hypothetically make all wages almost nil, and then you ask the employers to employ them, are they going to employ? No, that is the point, that the elasticity of employment with respect to wages so low that even if you reduce the wages substantially, no employer is going to sort of absorb them. Why is it so? Because you don't need those human beings. The machines are enough to do that, and that is what the view is. That even in very small units, in medium-sized enterprises, in large enterprises, there has been a steady increase in the capital labor ratio, and this is certainly not because of the strict labor laws.
I just will supplement the point Arup made with the three actual cases. Since I am working in a B school, I'm expected to do this. Asian Paints, Siemens India, Century Rayon, almost all these companies have multiple plants, and the new age plants are fully automated. And many of my students are HR managers. They are not IR managers, they are HR managers, because there is no category called workers category. They only employ supervisors, and they employ apprentices because of the apprenticeship patch. So there is a shift away from manual-oriented old plants to the modern plants, which is highly automated or highly robotics-driven. I gone to the Mahindra plant. My job is to visit companies to see. I mean, the painting or the minutest of the screw fitting, everything is done by the robots. All you require is one robot engineer. That's all, supervisor and an engineer. So to that extent, the capital intensity, innovation, all these things, maybe they are entrenched in the economic processes, which are not anyway, which are extraneous to the labor laws. Thank you. Amit, you wanted to come in.
Can I?
I will just come for a. I will just come for a.
Okay. Professor Sharma, yeah.
Yeah, I think I also reiterate the point made by Arup that although there has been de jure labor rigidity, but de facto, and several researchers have written about that, there has been a lot of flexibility in the Indian labor market. So that it should be understood in that context. Regarding one point made by Dr. Sahu about this strike and casual leave and all that, I think you see, you are dealing with human beings. In all civilized countries, democratic countries in the world, it has been thoroughly recognized, and from the pre-independence period, Trade Union Act was passed during colonial government in India. And trade unions played a very important role in independence movement. So, workers' rights have been a very important part of democracy or industrial democracy. So, in that context, already the space for collective bargaining have been shrinking. Strikes incidents have considerably come down. In that context, I believe that for enhancing workers' bargaining capacity is a very important step, and these labor codes erode to some extent either casual leave, not casual leave, go slow. A strike is the ultimate weapon by which the workers make their point. So I think these points should be understood. By the way, Tamil Nadu, labor, Tamil Nadu and Kerala, these are two states where wages are quite high. These are industrialized states, mostly Tamil Nadu, where labor enforcement machinery is also quite strong. So I think there is hardly any relationship between labor rights and productivity.
Can I just 2-3 minutes, because Prabhakar has actually raised quite a number of issues, but probably I don't think that some of the stress that we laid, and Alakh did, Arup did, I did, all of us said that labor reforms, or labor law reforms is what Shyam calls, comprising simplification, rationalization and harmonization, was something which was well understood. There was a consensus that it needed to be carried out. And I also pointed out that the commission of which I was a part gave a very detailed blueprint of how to undertake all of this. So the idea that labor law reform was not on the agenda, has not been argued by all of us or some of us, is not correct. That's number one. Even if de facto people are able to reduce labor market flexibility, there was a case of making de jure changes in labor law reform, and many of us have argued that. However, given the labor market conditions in India, the basic argument is that labor law reform, which addresses only a very small segment of workers, alone will not work unless it is accompanied by leveling up, by introducing social wages, by introducing social security and so on for the very large swath of workers at the bottom. And basically, this is the key instrument in reducing duality in the labor market, and not the other way around. And this point has to be grasped, and also the fact that this is the point, this is what can lead us towards inclusive development and more equitable development. Finally, this issue of what China did and Vietnam did and Bangladesh did, we need to have perhaps another discussion on this in the much longer. But I was lucky, and I sometimes think that the younger scholars won't have the chance now to do a very comprehensive study of two sectors, construction and garments, in India and China a few years ago, and also had an opportunity to spend some time visiting, Chinese apparel factories and looking at the structure, and came away with clearing many misconceptions that I had. But just to give some broad data, there was a time that, in the India share and China share, when the MFA was being lifted in phases, our share in world trade in apparels was roughly similar. And China increased its world share by about 8 times, between the mid-90s and the late 2000s, whereas India's share increased by just about 1%. And then we were rapidly overtaken by Bangladesh, Vietnam, and so on. And all this had very little to do, I'm afraid, only with labor laws. It had to do a great deal with infrastructure, with the quality of the workforce that was there, actually it also had to do with factory level, with basically shop floor management of industrial productivity, which I happen to see and look at in great detail. So a number of factors, infrastructure, many factors contributed to the fact that these economies were able to make a dent in labor-intensive manufacturers and labor-intensive growth compared to India. And I would finally say that, in our last volume, in the last volume of the NCUS report, there is the introductory chapter of this argument actually addresses some of the very questions which Prabhakar has raised. Why is it that we, because of our demand structure, we began to cater to capital-intensive products? Why we entered the global market, selling more capital-intensive products than labor-intensive products, and it was part of a much broader, a gamut of issues which we failed to address. Labor regulation was certainly one part of it, but was not the only part, as Prabhakar seems to suggest.
Yeah, I'll just make one response that FDI is highly legality oriented, and labor regulations in India are perceived to be tough. That is not so. Even World Bank survey of 72 multinational corporations clearly showed that they didn't perceive labor regulation in India to be one of the top 7-8 irritants. So it's nothing of that kind. It's the question of, and of course, David Kucera's paper in the International Labour Review clearly showed that good capital chases a well-made labor force, high labor standards, rather than good capital will chase low labor standards. This particular insight had to be reflected upon, and there is no connect between FDI and perception of labor law being tough, de facto and de jure, and all those things then will complicate the story much further. Thanks.
Amit, do you want to add anything, or do you think enough has been said on that? Okay. So now we can take, because we have unmuted Nisa Srivastava. I don't know if your question might have been already answered, the China related one, but you are unmuted. You can quickly ask your question.
Hello. Yeah, I'd just like to congratulate IAG and the excellent panel for very interesting presentations. My question is, yes, as you say, it has been partially answered, but also I wanted to know from Sundar, especially since he mentioned about this China, Indian government trying to fill in the place where China seems to be falling out, or that China is getting out of flavor from global supply chains. Can India take that place, or at least some part of that? Is that possible? Is it happening, or is it possible? And secondly, the other question very quickly is that if we don't believe in labor inspections and inspection rajas and the fact that they may not be achieving the purpose for which they were set up, can we think of alternative grievance redressal mechanisms for labor? How are other countries doing it? how about using technology for it? How other institutions in India are doing it? For example, in railways, how they take. It seems to me that the railways, they take grievances which you put into the box, and the emails that you send, they take it pretty seriously. So, and you also have a record of how many grievances were sent, how many were dealt with, and so on. So, if for labor, if you can have alternative grievance redressal mechanisms, how much is that possible? Thank you.
Thank you very much. This China baiting is a kind of a political economy twist to the need for labor law reforms. The government needed economic, social, and political legitimacy, and coincidentally, the COVID thing happened, and China became notorious, and then they said that China is being disoccupied, and then that presents a golden opportunity for India to occupy. But there have been several articles in the business press even to say that this is a misplaced argument, and India doesn't have the kind of things that Ravi also mentioned, in order to be able to get the contracts reallocated or the capital to be shifted from China to India. So I see it more as a political economic legitimacy argument rather than having any credible basis. Secondly, the European countries, the European industrial relations model has been to strengthen workplace industrial democracy, which would mean there could be work councils, there could be consultative bodies which are empowered, like joint management councils, shop floor councils, or work committees, or various bipartite arrangements, and also strong trade unions, which make the public sector inspection a kind of a complementary to the existing bipartite institutions. But in India, since the bipartite institutions were found to be weaker during the command economy, a larger, more powerful role for labor inspection was conceived. But over the period of time, bipartisan did not take the kind of shape that the planners had in mind. So we have a dual infirmity. Bipartite institutions are weakened, public sector inspection, that is the baby with the baby water, is being thrown out. So in that sense, there is a dual infirmity as far as the labor market governance is concerned. But I just want to make one point which Amit mentioned. The macro statistics of labor inspections will show a decline, but I have interacted a lot with the labor inspection machinery because of my ILO projects. What the employers are saying is that the labor inspectors do know which enterprises doors should be knocked at to be able to get the bribes or whatever the payments or the rent seeking, whatever it is. So in that sense, it constitutes harassment. It is not a harassment in a macroeconomic sense in terms of macro statistics, which even standardized with the establishment will show a very deep decline. But it is a concentrated, selective, discretionary inspection which constitutes harassment, and they form the powerful lobby of the industrialists, and thereby it gained currency. Thanks a lot.
Thank you, Shyam. Nisa, I should have said hello to you. This is Ajit.
Hi, Ajit.
We go back.
Nice to have you back in India.
Yes, well, I'm struggling thanks to COVID, but we're doing okay.
Yeah.
Thank you all. We could go on for a few more hours, and in fact, probably we should have one more round at some point, because I had so many questions, but I was trying to be the nice host, so I decided others to have a go at it. I'll of course be writing to you, because you see, when I started this, I'll take half a minute. I'm telling myself, when during just the brief unlocking, we had a webinar, and a top corporate leader was asked this question about labor law. Okay, I'm not going to name him. But what he said is that here we have a system where we have a dualism, which all of you have referred to, but in a very different kind, he was mentioning. That you have a completely one which is unprotected, obviously the unorganized sector, and another segment which is highly protected. Okay, So looking at these two, he said, "Oh, that's why I welcome all reforms, all labor laws, and stuff like this." Hoping that we'll kind of converge to the middle of where the right amount of protection is there. But obviously, the way I gather from your views and your comments and things, that that's certainly not the way to look at it. That if you just take out the protection from one, and it doesn't become that we kill the dualism. And as many of you have expressed, dualism is going to stay on in some form or other. With that, I thank you all, and hope to see you again. Maybe have a proper half-a-day workshop or something on labor issues, and in a proper, if possible, not through a virtual mechanism, but virtual medium, but face-to-face. So maybe in March, April, I don't know when. And you want to add anything?
Thanks. It was a good discussion. And
okay.
Thanks for calling all of us.
Yeah, I mean, wish we get some more time, but I have another at 6. So I'm going to thank you. Mausumi will probably say something, and then.
Thank you, everybody. It was an excellent discussion session. I think all of us a lot. And as it says, that we hope to learn more in a more sort of focused workshop sometime next year, post-COVID. So thank you very much to all the panelists and the attendees.
Thanks, Ayiji, for a live.
Thank you.
Thank you.